I'm going to be talking about Proposition 8, gay marriage. Last November, it was voted upon that gay marriage was to be banned from California state law. As it said in the LA Times, some supporters of same-sex marriage look at the ballot results and understandably conclude that California voters, with their passage of the Humane Farm Rules in Proposition 2, care more about the rights of chickens than that of gays and lesbians. The right to marry is inalienable, and it is biased to deny that right based on sexual orientation. Outlawing same-sex marriage further limits the civil liberties of equality for homosexuals. The Equal Protection Clause of the 14th Amendment prohibits any state from denying any person equal protection of the laws. In other words, the law of the state must treat an individual in the same manner as others in similar conditions and circumstances, such as heterosexuals and homosexuals. To ban gay marriage violates the equal protection provisions of the 14th Amendment by singling out one group to be denied the rights enjoyed by others. Attorney General Jerry Brown stated that Prop 8 exceeds legal boundaries of an initiative by withdrawing inalienable rights, equality, and privacy from a minority without a compelling reason. In California, a gay couple is unable to achieve the status of married, whereas heterosexual couples can. Gay couples are able to achieve civil unions, but calling marriage between same-sex couples anything other than marriage constitutes as unequal treatment. By claiming that the term marriage is merely symbolic, Carl M. Mannheim of Loyola Law School says that it's like telling black people that sitting in the back of the bus is not important as long as the front and the back of the bus arrive at the same time. New York Governor David Paterson stated that there is clearly a problem when gays and lesbians in civil unions are denied 1,200 to 1,350 civil protections, such as health care and pension rights, because they're not married. Gay marriage is an inalienable right which should not be subject to majority vote. In May of 2008, it was voted upon that gay marriage was allowed in California, but come November, that right was taken away because it was unlawfully given. After the outcome of Proposition 8, Senator Mark Lino of California announced that overnight, the rights of thousands of tax-paying, law-abiding Californians were stripped from them by a simple majority vote. Prop 8 defendants declare that since marriage is defined as a union between a man and a woman, for homosexuals to keep that right to marry, the legislature would need to make a 2/3 vote in favor of a revision of the Constitution. In the Press Democrat, San Francisco local Kelly Rivera Hart claims that there is never a time when it is for the majority to decide the rights of a minority. The fight for gay marriage is essentially a part of the eternal bid for equality of all. Although Proposition 8 outlawed same-sex marriages, in between May and November of 2008, more than 18,000 same-sex marriages took place. These same-sex marriages that took place were a step in the direction of equality. Back in 1967, there was a case, Loving versus Virginia, where it was debated whether or not interracial marriages were allowed. The winning statement was that marriage is one of the basic civil rights of man, fundamental to our very existence and survival. Under our Constitution, the freedom to marry or not marry a person of another race resides with the individual and cannot be infringed by the state. Loving versus Virginia was another great step towards equality and coincides with the right of gay marriage, which may just be the next step to be taken. Prop 8 is a part of one of the largest struggles for equality in decades. The hope that gay marriage will be completely accepted into society keeps getting brighter and brighter. According to the San Francisco Chronicles, in 2000, 61% of Californians voted to ban same-sex marriage, and in November, that figure was 52%. With the right to marry being undeniable, it is only a matter of time before it is universally accepted that lesbians and gays marry. Goodwin Liu of the LA Times stated that the more familiar we become with gay spouses and their children as our friends, neighbors, and coworkers, the more gay marriage will be an unremarkable thread of our social fabric. Thank you.
All right, I know what the topic is. It's not very clear what the claim is. It's, there is something that suggests that there's a claim. It's built into two parts, and at least one of those parts is a value argument, not a claim of fact. So that's a little bit problematic. There's no setup of what the structure is going to be on those supporting arguments, and in fact, it seems like one argument about it being an inalienable right is repeated 2 or 3 times. An argument about it being unfair is repeated in a couple of different places, and so I'm not exactly sure what the supporting points are. There's no numerical signposts on those points, and so you're not helping the audience follow the structure. It's a narrative type argument that follows a stream of consciousness as opposed to some logical division of ideas that it's going to be easier for the audience to follow. I thought you did a very good job citing your evidence consistently, telling us where the information that you cited came from, particularly when opinion evidence was being offered. You used examples of court cases, and you had some factual data about past votes that you cited, and I thought that was pretty good. You do make an analogy to the racial issues in the past. I think you're going to need to justify that analogy a little bit more. Like I said, you kept repeating a couple of points about inalienable rights. There are a lot of presuppositions built into this, and I think that if, for instance, we were doing this as one of our debate topics, which is quite possible because it usually comes up as an option, you would get a lot more explanation about why this is a complex issue. As it is, mostly we're getting the argument about how unfair it is and that it violates the rules. Although, if Jerry Brown's opinion is that it violates the Constitution, but the state Supreme Court's opinion on that doesn't appear to coincide with the Attorney General's. So I think that you need to put it in the context of what's been decided in this situation. I thought that your voice was pretty effective, but you don't really look at the audience while you're speaking to us, and that undermines your credibility a little bit. All right. Thank you.